Okay, I was talking to this kid about the rules of professional conduct. I helped him with a case several years back, maybe about 8 years ago, and they eventually threw it out. But when he went to court, public defender told him, "Here, sign this and you can leave." And I told him that that was ineffective assistance of counsel. That wasn't just ineffective assistance of counsel. That was destructive, defective assistance of counsel. Simply the fact that you didn't give informed consent. I said, did he discuss the rules of professional conduct with you? I says, he didn't even try to defend you. He just said, here, sign this and you can go. And I said, you know what you're going to leave with? A felony. So we discussed a probable cause hearing, and so the public defender came and told him, here, sign this and you can go. It'll be all over. He said, what is that? He says, just a waiver or whatever. And he said, what is that? Is that a felony? I said, yeah, that's a felony. So it happens to everybody, but I explained to him. And he says, well, what about a probable cause hearing? Public defender says, judge ain't going to like that. So he went and talked to the state's attorney and then to the judge. Judge was all upset, said, I know where this is going. The public defender didn't ask very many questions, and it was shipped off to Cook County Court for a trial. And they kept trying to talk him into just taking a plea deal. But they had no probable cause for arrest, and they found out when they reviewed the police report. But nobody would admit to it. So when he tried discussing, he didn't read the entire, just little bits and pieces of the rules of professional conduct. When he tried discussing it to him, they tried telling him, lawyers always do it, that it doesn't mean what he thinks it means. And they'll tell you this about this too. What you read, don't believe your eyes. Believe me, I'm going to talk some legal talk, a language you don't understand, and you'll think because I'm a lawyer, I'm a judge, I must be knowing what I'm talking about, so you're just going to do what I say. So let's talk about, I told them that they would be violating the letter of the law. So penalties for violating the letter of law can include fines, imprisonment, and by other sanctions like license revocation or paying civil damages, depending on the severity of violation, whether it's criminal or civil offense. Criminal penalties can range from minor infractions to serious offenses like felonies, potentially leading to a life sentence or even death penalty in most severe cases. Common penalties: find a common penalty in both civil and criminal cases. The amount often depends on the offense and the jurisdiction. Imprisonment: this can range from short jail sentences for misdemeanors to a long prison term for more serious crimes such as felonies. Civil liberties: in civil cases, a violator may be required to pay damages to the injured party or pay civil penalties. Okay, factors influencing penalties. Okay, so the letter of the law, that's penalties for violating the letter of the law. Okay. So letter of the law is pretty easy law, I was telling them. Letter of the law refers to the literal exact meaning of the law as written, without interpretation of its underlying purpose or content. It is the strict adherence to the text of rule or statute which can be contrasted with the spirit of the law or intended for goal of the law. And when I use the letter of the law, I cite the spirit of the law so that we all see, say, and hear the same thing, so there's no misinterpretation. Okay, so I always refer to the letter of the law because of the penalties of violating the letter of the law. Saying other than what is said there, according to the letter of the law, is disinformation. Okay? I was explaining this to the kid. Disinformation is false or misleading information intentionally created and spread to deceive people, often for political or economic gain. It differs from misinformation, which is false information spread without the intent to deceive. Disinformation can be spread through manipulated content, misleading context, fabricated stories, and rapid spread via social media, and made a significant threat to public discourse and democratic institutions. Intentional creation. Disinformation is not an accident, it's deliberate, okay? So, let's discuss penalties. Penalties for disinformation. Penalties for disinformation vary by context and severity, ranging from civil fines and social media restrictions to criminal charges, including imprisonment for serious offenses like defamation, fraud, perjury, and intentionally causing public harm. Specific penalties depend on the type of disinformation, the harm it causes, and the jurisdiction. Example for penalties. False reports of misdemeanor can lead to jail sentence up to 6 months and a $1,000 fine and or probation. Perjury or fraud, most serious charges can be filed in addition to false report. Imparting false information, conviction or conveying false information with reckless disregard for human life can result in imprisonment up to 5 years and or a $1,000 civil penalty. Bomb hoax. Okay, so penalties for disinformation. Okay, so remember, when interpreting the law, use the letter of the law. Going outside the letter of the law is disinformation. There's penalties for violating the letter of the law as well as penalties for disinformation. And disinformation, simply put in layman's term, is lying out one's rectum, one's tuchus. Lying out your ass, talking out the side of your neck. All right, that's disinformation, and it's illegal for lawyers and judges, you know, to violate the letter of the law, because that's disinformation. Penalties for both. That's what I was trying to explain to this kid when he was trying to understand the lawyers and the judges, what they were saying about the rules and the codes. I said, just read it. Read it. Just read it yourself. Those are the laws in a court of law, and nobody's doing that. I printed them out, gave them to him, told him to highlight every issue, everything that didn't happen in court. And there's a lot of stuff that didn't happen in court. I asked him, did you read it? Well, a little bit, here and there. And I wanted to yell. I was mad because this was years ago. And I told him this will serve your future as well as your present and your past. So he's thinking there's nothing he can do about it. But there are no statute of limitations for violating one's constitutional rights. He had ineffective assistance of counsel. The judge didn't cite his lawyer for ineffective assistance of counsel. The state's attorney didn't cite his attorney for ineffective assistance of counsel. And it's mandatory to report misconduct for violating any of the rules or the codes. There was multiple counts of misconduct. And since nobody reported any of that misconduct, that's misconduct, because everybody was legal to report each other as well as themselves, and nobody did it. And that's what's called a conspiracy against rights under the color of law. Okay. Conspiracy against rights under the color of law is a federal crime where two or more people conspire to violate a person's constitutional or federal rights using the guise of official authority or power. This applies when an individual acts under the color of law by wielding power granted by a government entity such as a police officer, judge, or other public official. Penalties can include fines, imprisonment up to 10 years, or in the event of death, or even or even the death penalty in cases resulting in death, kidnapping, or aggravated sexual assault. Key components, color of law. This refers to the appearance of official authority when a person acts under the guise of government position, even if their actions are illegal. Conspiracy. The crime requires an agreement between two or more people to commit the unlawful act. Deprivation of rights. The conspiracy must have the intent to injure, oppress, threaten, or intimidate someone, and free exercise of rights or privilege secured by the Constitution or laws of the United States. Example of these rights. These rights include, but are not limited to, the right to vote, the right to be free from unlawful searches and seizures, the right to be free from cruel and unusual punishments. Penalties. Standard penalties, fines, imprisonment for up to 10 years or both. Aggravated penalty. If the conspiracy results in death, kidnapping, attempt to kidnap, or aggravated sexual abuse, the penalties can include fines, imprisonment for any term of years or life, or even a death penalty. Examples for violation: law enforcement misconduct, a police officer falsely arresting someone using excessive force or confiscating property without proper cause is violation. Election interference, efforts to prevent people from voting or to stop the vote count from being properly conducted, can be prosecuted under this law. Abuse of public office, a public official using their position to threaten or intimidate citizens into giving up their right can be held accountable. So is that public defender simply telling this kid, here, just sign this and you can go, it's all over, you don't have to come back? That's illegal. That's an effective assistance of counsel. At what time did he get informed consent from this kid that he knowingly left with a felony? And then when the kid tried to discuss the rules and the codes, tried to get the judge to cite the attorney for ineffective assistance of counsel, but he didn't. That's all he had to do, is tell the judge, Your Honor, do your job, cite my attorney for ineffective assistance of counsel. And it would have snowballed from there. It's the judge's job. It says so in the rules of professional conduct and the code of judicial conduct. It's mandatory to report any violations in either or for all lawyers and judges. So he's supposed to come over sometime when he has the time, and I'm going to go over every law that was broken just to get him to sign off on something that didn't happen. I told him it's just, for statistical purposes. You're there for a matter of statistics to show that they're doing their job, being tough on crime. And then being tough on crime is simply violating every law in a court of law to make the innocent look guilty, and the adverse as well, to make the guilty look innocent. And so they decided to withhold the evidence, and it could have been easily proven having the cop testify to the police report, but having him do that would have proved no probable cause. Rule 3.8, special rules of prosecutors, special responsibility of prosecutors to see to it that no case is brought forth that has no probable cause. So even though the public defender didn't bring up there was no probable cause, it was the state's attorney's duty to bring up no probable cause, as well as the judge. I only seen one judge do that, and it's a gentleman in Texas. State's attorney decided to pursue a case without probable cause. So the judge has a probable cause hearing, questions the defendant, and threw out quite a few cases because there was no probable cause. Still had the duty to report the state's attorney for violating the rules of professional conduct. And you can't just violate one rule. You violate one rule, it winds up being multiple violations. You wind up violating multiple rules. It would have been diligent to cite no probable cause. It would have been competent. Failure to expedite that litigation is a mass incompetence. Okay, people, I'm gonna let you go right now, and I just had to do this short one. The kid wanted to talk to me about a lot more, and I told him I already talked to him about it. He didn't understand it. All these issues he was bringing up, I read these laws and what you can do about it. People violating these laws. So I told him, just go through the videos. Pick and choose the ones you want. I mean, if we sit down and talk, I'm literally going to be going on the internet and doing this with you when I already did it. Put it on videos on the internet. But somehow it seems to sink in quicker and somewhat easier when I'm in his presence. Okay, remember Civil Rights Division, just look up government agencies with civil rights divisions. Okay. And they will prosecute and sue on your behalf, according to their website. It's federal law, breaking federal law, conspiracy against rights. I don't know what happened there. Okay, but you know, anybody can file for a conspiracy against rights under the color of law in any court of law. For so many different reasons. And it starts with deprivation of rights. Your lawyer not getting informed consent from you. And informed consent requires reasonable knowledge to make an informed decision to give that informed consent. And that reasonable knowledge would be knowing that, number one. Number two would be knowing your lawyers and the judges, every lawyers and judges' legal responsibilities to you in a court of law. And those are stated in the Rules of Professional Conduct and the Code of Judicial Conduct. That's the guarantees of the Sixth Amendment in the U.S. Constitution. That's effective assistance of counsel. The lack of effective assistance of counsel is a lack of a fair trial. The lack of a fair trial is a lack of due process. makes the 14th Amendment, a due process clause, totally worthless. You know, when I was younger, back in the 80s, 90s, people called me a conspiracy theorist because I quite literally used the literal term conspiracy against rights under the color of law. Well, back in the 70s, I first used deprivation of rights under the color of law. Conspiracy of deprivation of rights under the color of law. And then I think it was somewhere in the 90s, I come across this, a conspiracy against rights under the color of law in 2000. I just kept reading, kept looking, because the more I used the laws, they started changing the terminology, the verbiage, you know. But it's, you know, the song still remains the same. You know, when I first started filing fee waivers, before it was a waiver of fees. Before that, what was it? I remember it was a motion of pauperous at one time. An indigent statement afterwards. Doing this for a long time. And this is what it's based on. You know, if you aren't, and any of you have ever been in a court of law and needed a lawyer, and you don't know what the hell is going on in there because you don't know what anybody's saying, that's totally illegal. How is that a fair trial when you don't even understand the language? That's why I'm showing you all these laws, because they're them not abiding by the letter of the law is. I already went over that with you. All right, but that's up to you to determine. Open your eyes and you open your mind. All you got to do is read. Read to succeed. You know, I'm pushing 300 videos, I think, on YouTube, 250. I don't know how many on TikTok, but I'm doing my best. You know, you seriously don't have a chance unless you've obtained that legal knowledge of a legal seasoned, learned professional. You don't have to believe me, believe your eyes. Google the rules of professional conduct and read it. I'm going to do a video with this kid. I told him it's going to take about 4 hours, so I have to put it on YouTube. And they only allow 2-hour videos. That's the longest I get. So it'll take about 4 hours just to go over all the laws that were broken. And the only reason it's going to take long because I want to go over the penalties for all the laws that were broken. And they threw the case out eventually, but I even explained to him that he was denied and he didn't know. Quick and speedy trial is a constitutional right of accused person to have a criminal case take place within a reasonable amount of time after being charged, the right guaranteed by the Sixth Amendment prevents indefinite detention and ensure that after a trial by minimizing the harm caused by the delays such as fading memories or lost evidence. While the U.S. Constitution doesn't specify exact time limits, the Quick and Speedy Trial Act of 1974 sets federal limits requiring indictment or information within 30 days of arrest, and a trial to begin within 70 days of the indictment. Okay, key aspects of a right to a speedy trial. Okay, so I mean, if in any case, I've watched on the news people complaining they've been waiting a year and a half, 2 years to go to trial. What's going on? And so many people being denied. I only seen one case where a couple guys were cut loose shooting at somebody. They got caught with the gun. It was proven that they shot the guy or at the guy and chased him out of the neighborhood because they didn't know who he was or didn't like who he was. But anyways, the judge threw the case out because state's attorney's office exceeded their right to the time limits to a quick and speedy trial. State laws may vary, but when I went over the time limits on his case, and considering it was a year before they dropped the case, he was also denied a right to a quick and speedy trial, effective assistance of counsel. There was deprivation of rights, a conspiracy against rights under the color of law, violating the letter of the law, violating the rule of law. So many different laws. Well, at least he's talking to me again. You know, he was mad at me, but it wasn't. He was having, it was during when the coronavirus started. He was having some hard times, and he worked in the food industry, and they were the first hit hard. He had money problems, and but he thought he lost all chances of resolving it, even though they threw the case out. There was still the deprivation of rights. There was still the conspiracy against rights under the color of law. It took them some time to get them to capitulate. But they did. And he thinks it's over. I told him, no, it's not over. I told him about filing a complaint, whistleblower complaint, conspiracy against rights under the color of law complaint, deprivation of rights complaint, filing with the ARDC, Illinois Attorney Registration Disciplinary Commission, the Illinois Judicial Inquiry Board, filing a motion. Well, the case is over with, so a motion to quash, but a writ of habeas corpus. But no, that's if he. But either way, he can file for deprivation of rights and a conspiracy against rights under the color of the law. Took a lot of time out of this kid's life, and he had to sit at home under house arrest, and he wasn't allowed to go anywhere. And he did what they said. And you know how most people get when they're confined, even if it is at home. All right, people, I just wanted to let you know a little bit what I was talking to this kid about. Talked to a lot of people about, way back in 1979 till now. That's what I do. All right. You have a good night. May your Creator always be with you. I wish you nothing but a long life and good health. Many blessings, my friends. Many blessings, and I hope what you find in my videos are some of them. Good night.